and his associate Meghan Reed.
Thank you, Maria. Good morning, everyone. It's a beautiful fall day in upstate New York. We're on our 17th straight beautiful fall day, so thank you for joining us and venturing out in the cold. My name is David Whitcomb. I am the owner of Whitcomb Law Firm. I'm also a part-time city court judge here in the city of Canandaigua. I was appointed in 2000, and when I took the bench, it was the pandemic and there were no people in the court, so it was an interesting introduction to being a judge. But anyway, we practice in the areas of real estate, estate planning, estate administration, and estate litigation, also business and various other things. We also have a personal injury component to our law firm as well. I'll be emceeing today. We're gonna keep it light. We don't have a projector or anything because that can get a little boring. We figured, why make it something you can just watch online? We're here, probably best. We've got an outline of what we want to do this morning. Topics we're going to cover are obviously wills, the importance of having a plan, a living will or an advance directive, healthcare proxies, power of attorneys, the basic documents. Everyone's individual circumstances will dictate what the plan is. You may need a trust, you may not need a trust, you may simply want a trust. There's 1,000 different types of trust. There's some basic ones that are kind of more used than others. And then there's end-of-life planning, long-term care planning, and Medicaid. Medicaid's an interesting topic to cover because by the time we're done sitting here, the law will have changed. And this morning, Congress passed, well, I shouldn't say Congress, the House of Representatives passed the budget bill, and it included changes to Medicaid. I haven't even seen what those are yet. And that doesn't mean that's what's going to look like when it goes through the Senate. So there are changes to Medicaid coming, and once we know what those are, we'll let you know. And I'm going to turn it over to Meghan.
Good morning, everyone. My name is Meghan Reed. Like Dave said, I've done estate planning, long-term care planning. I do a lot of the estate administration. I also do Medicaid applications, so I know a lot of the rules, little caveats in regards to how does somebody get on it if the event they go into a nursing home. Is it applicable for home care? So we're going to address some of those questions. We do want to kind of keep this where if you have a question at any point, please feel free to let us know. So you don't have to save your questions to the end. If it pops into your mind, just let us know. Because if you're anything like me, by the time we get to the end, you're going to forget your question. So please feel free to just let us know. A little bit about me. I'm Syracuse native. I've been an attorney now for 13 years, and I've only done estate planning, like I said. I joined Dave about 1.5 years ago, and it's been great. We really work on trying to figure out what is best for each individual that comes into us. So that's what we're going to kind of go over today, is just how we would do our consultation with you. This is what these documents mean. These are some of the misconceptions that are out there, and that's kind of where we're going to start. Some of the misconceptions about estate planning. The biggest one is, I talked to my neighbor. They said I have to have this. That is not necessarily true. Everybody's plan is different. Why? Everybody's family structure is different. Everybody's assets is different, and everybody's goals is different. So when it comes to developing your plan, what you want is primary. That's one of the first questions we always ask everybody. What brings you in? What is driving you to make your estate plan? Because then we can always tailor it to what's best for you. What's best for your circumstances. One of the biggest misconceptions that we hear is, in the event I don't have an estate plan, no will, nothing, the state takes all of my money. That's not true. What happens, though, is the state determines who gets your assets. Now, example one would be husband, wife, husband, partner, whatever the case may be. In the event you pass away, you assume, well, I have nothing in place, but all of my assets are going to go to my spouse. Not true, unless you have beneficiaries or a will. The law states, and it's called the law of intestacy, meaning I passed away without a will. They say the first $50,000 goes to your spouse, then it's split 50-50 between your spouse and your kids. So that's not always everybody's plan. You say, no, it's supposed to be everything goes to my spouse. So that's one of the reasons why you have a will in place. Why we always want to make sure your beneficiaries are in place. How are things titled? Because intestacy law says that. Absolutely.
Let me tell you a quick story on that. I had a client many years ago. She was married. Her husband had multiple children from prior relationships. They had one child together. And he was a traditionalist, we'll say, and he wanted all the assets in his name. And she did. They had a family home that was her father's father's father's, you know, from the Revolutionary War type of thing. And they deeded it all into his name. He retired. The next day he passed away, had a heart attack, and died. Problem was, they just assumed, as Meghan's saying, that, well, it's okay, if he dies, everything's gonna go to me as the wife. Not the case. And what made it worse was there were children from prior relationships that lived in, I think, 3 different states that hated her. And it was a battle, because while she was entitled to the first $50,000 of the estate, the rest of the assets were subject to division amongst everybody, and we had to fight with the kids, and it was just it wasn't pretty. All because they were acting on an assumption of what they thought was the case. That it could have all been avoided by simply writing a will that said, I leave everything to my wife, and her saying, I leave everything to my husband. So we've seen firsthand, time again, these misconceptions that people have turn into nightmares.
So that's where the planning really comes into place. It's just kind of saying, well, this is not what the law actually says. The other thing is, well, it doesn't really matter who I pick as an executor, as a power of attorney, as a healthcare proxy. That's not necessarily true. You want to make sure you're picking the person, the individual, who's the most capable of handling something. And not every fiduciary is the same. You might have somebody as your power of attorney because they're really good at finances, but they might not be your healthcare proxy. You do not have to have the same people for each role in your life. I always use my brother as an example. He's a PA, I'm an attorney. Don't have me make the healthcare decisions, have him. Even though he's younger, doesn't mean he's not gonna talk to me. He's better apt to understanding what they say. I'm like when you watch Grey's Anatomy, they start talking medical, I glaze over. I have no idea what's going on. However, financial side, that's something that would be more apt for me to handle. So it can be a cohesive working, but somebody might be better apt to doing something. If you've got a family member who's never been good with money, can't balance a checkbook if their life depended on it, maybe not the best choice. So that's some of the conversations that we have to say, well, let's be conscious of who we are choosing to act in these roles that we pick.
What happens if you don't pick somebody?
And if you don't pick somebody, anybody remember back in like the late 90s, the Terry Shriver, woman in the coma for 20 years down in Florida, the fight between the husband and the parents, who made the decisions? Nightmare. In relation to that, a lot of the states issue laws to say, well, in the event you don't have this, in regards to healthcare proxies, we've established the order of which we're gonna pick. It'll be spouse, then it'll be adult children. Well, I may not want that child to pick it. Why? I don't have a relationship with them. What if I don't have a child and I want my sibling to be that agent? So the law would pick it for that case. In the event you have a power of attorney, because in New York State they are 2 separate documents, in a power of attorney case, meaning somebody who handles your finances, if you don't have somebody in place, you have to go through the court system to do that, and that's called a guardianship proceeding. The judge gets involved, extra attorneys, you're going through the court system to try to get somebody appointed. Wherefore, already having a power of attorney in place negates having to go through the court system to get somebody appointed. Because even in the event of our incapacity, we all know, those bills are still showing up on the dot that first of the month having to be paid. Any questions on that?
So those are just some common misconceptions and how they can lead to bad results. Yeah?
What if there are no relatives? I mean, everyone has died, you're the one, and is there a law about who you can appoint or leave something to?
Are you asking if you don't have any relatives that you want to either choose as an executor or a healthcare proxy or even leave money to in your will?
Am I asking what?
Are you asking, I think what I'm hearing is, are there rules on who you can appoint for these positions? As long as they're over 18 and competent, it can be anyone you want, including and up to your attorney, although we don't recommend you use us. Sometimes people in their circumstances do. I've had several clients say, Dave, I don't have any kids, I have 2 sisters, I can't stand them. My parents are gone, I have a brother, I don't trust him, he'll steal everything, would you mind doing it? And I advise them that you don't have to choose us, but it's an
But
option.
you still have the choices. just
Yes,
make-
it can be a friend, a lot of times it's a friend, a close friend that they trust because for whatever reason, they have family, but they don't trust them for this, other reason.
Well, I don't have any relatives left, but I have a good friend who has a brother she loves very much, but he is disabled as well as being in jail. And
That makes it logistically difficult to carry out the duties. Yeah, and Megan was touching on, you want someone competent, if you have someone in mind for a position in the roster of documents, maybe you have a nurse that's a daughter, she's probably a good choice for your healthcare policy. Whereas the accountant son is probably better suited to be the executive. But if he lives in California, that's gonna make things difficult. So you've gotta weigh all those factors when you're deciding. Someone who might be really good at a particular thing, they just might not be around to do it. So it's difficult. We often run into, I don't think anyone here is planning on having more kids, but maybe. Well, like if you appoint, sir, I'll give you 1 second. A guardian, for example, if you're gonna appoint guardians for your children, you might have somebody that's a great parents and they live right around the corner, but they already have 3 kids and you have 3 kids. Does that make sense to give them 6 kids to raise? But they live in the school district that your kids are already in. And whereas your brother who has no kids and lives in another great school district, but has half the state away and he's never been to dad before, There's just always competing factors when you're looking to appoint someone to a position.
Sir? Dave, I have a question. Is there such a thing as POD?
Payable upon death?
Yes.
Yes, so that's beneficiary designation, so those are done with the institution itself. So now I'll kind of segue into that. So that kind of comes in place with your will. You perfectly segued into it, thank you. So in regards to your last will and testament, what your will controls is those assets that are solely titled in your name alone at the time of your death. Anything that has a joint owner on it, or a beneficiary, payable upon death, passes according to those designations. So they supersede your will. So one of the things that we're always conscious of when we meet with people is saying, well, what assets do you have? Do you have bank accounts? Do you have retirement? Do you have life insurance? Great. How are those, A, titled? Are they joint with you and your spouse? Are they individually owned? And 2, who are the beneficiaries listed on it? The reason we ask is because, well, I set it up 40 years ago and I haven't touched it since. How many people can say that ever? Yeah, so we always say, well, now this is the perfect time to check those designations, because who I picked 40 years ago, or even 5 years ago, might not be who I want today. So that's always part of when we're talking about your will, how are things titled? Now, one of the things we always want to check too is, in conjunction with your will, beneficiary designations, payable upon death, is to say, how are we leaving it to people? Some people have family members that say, well, they're kind of a spendthrift, or we might have a grandchild that we want to leave money to, but they have a disability. So how we're leaving assets to people is very important as well. So if we have special needs grandchildren, we want to leave it in what's called a supplemental needs trust for them. So that can be created under your will, because you always want to leave things as evenly as possible, but there's ways we can leave it to them. And that's also key for beneficiary designations. The other thing we always recommend with beneficiaries, and we'll get more into the will in a second, is you want to check those at least every year. As we all know, companies constantly change hands. HSBC became First Niagara, became KeyBank. MetLife got bought out by Bright House. Even though they still exist, they're under a new umbrella. A lot of times, those new companies will not recognize your old beneficiary designations. Because we're saying, well, now we're KeyBank. We're not First Niagara, we're not HSBC. They don't tell you that. You just get that nice letter in the mail saying, hey, we're still gonna give you that same great service we've always done. Please let us know if you have questions. Meanwhile, they don't let you know that you should also double check to make sure the beneficiaries are still the same. So that's why we always recommend every year, pick tax time, you're already in that mindset of going through your finances, to check to see, does it still reflect who I want today?
And there's the human element as well. I'm glad you mentioned that. Another reason I want my clients to double check their beneficiary designations every year, or at least every couple of years, is you fill out a form and you send it in, whether it's a paper form or something online, but that doesn't mean they entered it right on the bank's end. Banks are full of people. They're, you know, the Supreme Court says companies are people, but they're not. They're just paper. The people there. I sat with a woman here in Canandaigua at her kitchen table. She was older and she couldn't make it into the office. And I said, well, let's just double check. You got a lot of money in these retirement accounts. The will is going to leave all the money equally to your daughters. And she's like, well, that's what my beneficiary. I left everything equally to my daughters in my 3 retirement accounts. Okay, that's fine. But I think it'd be smart, since I'm sitting here right now, let's just call it. And 2 of the accounts were exactly how she wanted them, but the 3rd account, which was the biggest account she had, and the biggest asset that was going to go to those 3 kids, the bank had put the one daughter as the primary beneficiary, and the other 2 daughters as backup beneficiaries. And that was not the plan. And she's like, Dave, that is not the paperwork that I sent into the bank. I said, I know, but obviously somebody on the back end in the data center put it in wrong. So we changed it, and we avoided a big fight between the daughters. She eventually passed away, and everything went smooth. So it's just, it can be a scary thing. Just double check. Sometimes retirement accounts, money market accounts, if they're transferred on death, you've got a beneficiary designated. Sometimes your statement you get in the mail will actually have it on there. Not often, though. So you've got to kind of inquire to make sure that it's correct. You want to segue into what the will is?
Sure. So like I said, what your will controls is those assets solely titled in your name alone. So even if you have all your beneficiary designations in place, in advanced directives, you always have your will as your catch-all, just in case that company changes hands at the last minute and I don't get the chance to update it. So your will say, well, this is who I want to receive my assets. Typically they say I want everything to go to the spouse, evenly between the kids. That's also where you decide too, like in the event your kids pass away, do you want it to stay amongst your children? Do you want it to go down to your grandchildren? Some people don't have spouses or grandchildren, so who can I leave my assets to? Anybody you want. You can leave it to individuals, you can leave it to churches, organizations, charities, you can leave it to whoever you want. People also don't realize, well, I'm involved in XYZ organization, let's say Make-A-Wish, for instance, but I want it, or the Wood Library, and I wanted to, so for Wood Library, I wanted to specifically go for the Children's Reading Center to help promote children reading. You can specify in your will, I want this donation to go specifically for this purpose within that organization, because that's what I was passionate about. That's what I want my legacy to be fulfilled as. If not, you can leave it evenly between all your kids. But again, like I said, not everybody has that.
I've got a client, he doesn't have any kids, and he's not married, and his entire estate is going to rhinoceros sanctuaries in southern Africa. Because he goes there and volunteers to man the line so that poachers can't get in. And obviously I can't tell you any more details than that, but if you met him, he does not look like the type of person that cares about rhinoceroses. But he does. And I said, if that's what you want to do, that's what we're going to do. It's going to be a heck of a time when you die trying to coordinate with these people, but we'll get it done because that's what he's passionate about. That's where he wants his money to go.
Your will is also where you appoint your fiduciary. So who do I want to be my executor? So your executor's sole responsibility is for those assets that pass through my will, they're managing it. So they're collecting them from your name and distributing them to whoever you have named in your will. That's their responsibility. Now, also under your will, we can also make provisions for kind of like what I said before. Well, I've got grandkids, but they're minors. I don't want necessarily a minor getting assets outright at 5, at even 18, maybe even 21. So I want to leave it in trust for them until they're 25. I'm going to appoint a trustee who can manage that money for them, take out money for them prior to 25 if they need it. Hey, trustee, I need a car because I'm working, I'm going to school. Okay, let's go buy you, a used Toyota, not a Ferrari. Where a kid at 18 might say, the Ferrari sounds so great, I have the money in there. And it's not exactly the most fiscally responsible decision, where the trustee is going to say, okay, I understand you need a car, but let's also preserve some of the money in here as well. And then once that grandchild reaches a certain age, the money would be turned over to them outright. So it helps protect them from themselves while they're still young. We also can plan, like I said, if we have any family members with disabilities, to say, well, we still want to provide for them, but we don't want to affect any benefits that they have. So we can leave it in, it's a statutory trust that is approved by New York State that does not kick them off their benefits, called a supplemental needs trust. That money is held in trust for their benefit, and it can be used to pay for anything that that grandchild needs throughout their lifetime.
And not just,
The purpose of that type of trust, if you have someone in that situation, is to pay for things they want, not necessarily things they need. They can use that money to go on vacation, buy a bigger TV, entertainment purposes. It's so that the person with a disability can enjoy life and not spend all their money just on basic care, medical care, housing, food, clothing, that type of thing. It's the one trust in the world that says, spend it all, have fun, don't save it, because if there's any left, it's going to go to New York State to reimburse the state for monies they've spent on care during life.
Maria?
Can you direct within the supplemental needs trust for specific care, like say a personal aid or something like that? Can that be written in that trust, or is that a different?
It's already in there. So supplemental needs trusts are designed and they have to be explicit with the statute in New York State, and it says that it can pay for aid. So that example, like Dave said, they want to go on vacation with the family, not only will the supplemental needs trust pay for that child's trip, it'll pay for an aids as well. So yes, it can be used to pay for that. As long
Healthcare
as
that's not covered by benefits.
yeah, healthcare that's not covered by any benefits they're already receiving. So if Medicaid is already paying for food, housing, clothing, the benefits cover that. This is for the extras. The other example of that would be that child needs a wheelchair. Medicaid's gonna pay for the $50 one, but they want the $100 one. The trust pays the $50 difference to get them the better one. So it's designed to supplement them so they still maintain all the benefits that they do. But it is a conscious thought to say, okay, I don't want to leave out this grandchild or child or whoever it is. So there is a way to plan for that. And I saw you had a question.
Yeah, you're talking about for the benefit of minors or someone that's disabled. But what if just setting up a trust instead of designating within the will? Isn't there, you set it up in a trust, then it avoids probate or something?
Yes, we're gonna get into trust shortly. So
Okay.
there's different kinds of trusts, like a revocable trust or an irrevocable trust. Yes, we're gonna get to those. You always have those in conjunction, so even if you do advanced planning, like a revocable trust or an irrevocable trust, you still always have your will. Again, you always want your will as a catch-all, just in case the beneficiaries don't cover anything or everything, just in case the trusts don't designate or own all of my assets.
Is there a law that says the executor is entitled to a fee out of the estate?
Yeah, so it's statutory, so the executor is entitled, it's based on a percentage. So they would get 5% of the first $100,000 of your estate. Now, when we say executor's fee, it's strictly based on the assets passing through the will. So it does not include anything that has a beneficiary on it. So say I beneficiaried $500,000 to Dave.
Thank you.
You're welcome.
I gotta go on reach now.
But in my will, he's the executor of $100,000. New York State says he can get a commission for doing his duties. Up to the first $100,000, he gets 5%, it's about $5,000. From $100,000 to $300,000, he would get 4%. From $300,000 to $500,000, 3%.
Yeah, it's a descending ladder, basically,
Anything,
as the amount goes up.
yeah, anything 500,000 or above, 2.5%.
Is that, now, you said the first what, the first,
100,000,
you get what,
5%,
and the next?
4. So that's the next
Okay, now-
200,000. Yep.
First 100,000, I get 5%, the next I get, the next amount, I get 4% or 3%, or is it 4% of the whole thing?
No, it's just 4% of that. So how it works out, best example, I've got an estate of $250,000.
Right.
He's gonna get a 5% commission on the 100,000.
Right.
So now I got 5,000 as executor.
Right.
So on the next amount, which is just 150,000, he gets 4% of that.
So it's 6,000. So it'd be, gonna be 5 and 6 together.
Yeah.
Correct.
So my commission's on that one,
Not the total of 4% of the whole thing.
Right.
Correct, correct.
Okay.
And
Commissions for an executor are considered earned income. So your executor is gonna pay tax on that. They're gonna report that as just income because technically it's a job. You're working as the executor of the estate. If it's an estate where we have 1 or 2 kids, most of the time, depending on the relationship between the kids, they waive the executor's commissions and just leave the money in the pool to be divided. Sometimes there's creditors we've got to pay. We want to, even though you're going to pay tax on it, it's better to get the money out of the estate and pay it as executor's commissions to the kid. There's always caveats to the way we do things and why. If you have multiple executors, they split the commission unless the estate's over $300,000. At that point, then they're entitled to full commissions. So it can get complicated. We tend to never advocate for people having co-executors. I generally tell my clients, it's best if there's one captain, of the regiment. 2 captains, we're sending troops in different directions, and it can lead to fights. And I like stories because I think it illustrates the blahness of when we talk about the law. I did have a case where the father died and he had 2 sons. He made them co-executor. The one son was down on his luck and he moved into dad's house. And we're like, okay, we're gonna sell the house for the estate. The son wouldn't leave, but he was co-executor. So first we had to remove him as co-executor, then we had to evict him. And as the fates would have it, that was around the end of 2019, early 2020. When we finally got the paperwork to get the kid out, the pandemic shut the courts down, shut the evictions down. He managed to stay in that house for almost 4 years and pay nothing. It was a big battle. If he hadn't been co-executor, we could have avoided a lot of that. So it becomes difficult, or just logistically, if you got 2 executors and you've got to sign a check or certain paperwork, moving money around, we need both of them to agree. We got to get them both to the office to sign things. It just kind of slows things down, even in the best of circumstances.
And the other thing we always recommend is just because you pick one as the executor, we always want you to have alternates. In the event this person can't do it, they passed away, who's the next person in place? The reason being, in the event that person at your death can't do it, you want to have somebody you pick to be that next alternate. Because they either might have, like I said, passed away, or I'm too overwhelmed, I can't handle this responsibility. Or a lot of cases we see with spouses, I'm just naming my spouse and then it'll be fine. Let's be honest, in the event of the death of your spouse, you're not going to be thinking about changing your own documents. You're going to be worried about, do I have everything good for them? And on top of your grieving process. So by having these alternates already in place in your documents, whether that's for your power of attorney, healthcare proxy, or this is my alternate beneficiary, this is my alternate executor, it's already in place. You already have that stuff. So you're not worried about, oh my gosh, now I got to go change my own stuff. Oh my gosh, I'm in the, in grieving process, I can't handle this right now. It's already set in place. So we always say, it's great you had your first, but what if this? What if that? We need to think next step. What if this happens to somebody? What if they can't do or act as this role? Who would you want as your next appointed person? Now, part of doing your will too, people have financial advisors, people have tax professionals. We always want to work with them, and we're always happy to jump on a phone call, have them as part of the meeting to make sure any plan that we're doing under your will is reflected on those beneficiary designations. That's always the key too. We could draft the most beautiful will you've ever seen, having the trust for the grandkids, the supplemental needs trust, but if that's not reflected in your beneficiary designations, your plan is for naught. So it's kind of it's a twofer. You gotta have it in your will, but then, hey, let's check how your beneficiaries are written. We will also too, when people come and they do a supplemental needs trust for a grandkid or do that minor trust, we'll give you the language to give to those institutions to put down as your beneficiaries as well. And that's key, because like I said, your beneficiaries supersede your will.
Some other things you want to think about when doing a will. The will itself is an opportunity for you to make smaller gifts. Maybe in my practice, a lot of times women will leave their wedding ring, their engagement ring, their mother's or their grandmother's engagement ring to their daughters or nieces. Men like to leave guns. Just generalities, doesn't apply to everybody. They want their guns to go to their sons or their nephew, or their hunting camp to go to their nephews. The car, the 1937, whatever, I'm not really a car person, but you get my drift. Or just smaller, I want to leave $1,000 to all my grandkids. I want to leave the hutch that was my great-grandmother's, make sure it stays in my side of the family, that type of thing. It's also an opportunity to make some directives if you want to let everyone know in your will what your wishes are as far as burial. Cremation versus burial. Some people feel very strongly about it. Some people have never thought about it until they come into my office. They're like, oh yeah, someday something's going to have to happen to me, isn't it? Like, yeah, and we can put that in the will and just so everyone knows what your wishes are. There's a different form, actually, if we want to fill that out, that directly dictates what's going to happen to your remains, but a lot of times you put it right in the will. I just direct that I be cremated, and my executor dispose of my ashes as they see wish. We get a lot of not really legal requests to dispose of ashes. I want to be thrown in the lake. Technically, that's very, very illegal. I'm not supposed to do that, but I'm sure people do it. But so there's a lot of little, smaller things that we can address in the will. Gifts you want to make, last statements you want to make. I've had a couple doozies, but this is your last chance to say something to your family if you really want to say it. And if you're excluding someone, we're going to mention that in the will. You have 3 kids, and you love your son, but he's just a financial nightmare, and you know that if you leave him any money, it's going to be gone in a week. Or maybe there's issues with possible divorce on the horizon, or drug issues, whatever it is. You love your kid, but you're going to exclude him. We usually put something that says, I recognize that I have my son Johnny, but I make no provisions in here for him for reasons that are known between me and him. Just so that he can't challenge the will later on, saying, well, I'm not in there at all. Mom must have dementia. She forgot I exist. Now we know you're there. We just have to make sure you're not going to get any money. Or we set up, like Meghan was saying, maybe we set up a trust for that kid. Say, okay, we're going to leave him some money, but it's going to be in a trust managed by his brother because we just don't need him controlling any money. So there's a lot of things that we can do with the will to accomplish a lot of different goals. Like I said, if you have young children, or maybe you have custody of a grandkid, you're going to use it as a chance to appoint guardians for those kids. If something happens to you and there's no other parent, you're going to have the first chance to dictate where are those kids going to go, instead of having a custody fight or guardianship fight after the fact. Power of attorney?
Any other questions? If you have a child that has died, is it necessary to take them out of the will?
No. No. A deceased person they're not going to inherit, but it depends on how you've written it. So, for example, mom and dad have 3 kids, one of their children predeceases them. How the will is written might already say, in the event that one of my children passes away, the money will go down to their kids. But if they have no kids, it then gets distributed evenly amongst the then living children. So it's going to depend. Ex-spouses, automatically stricken. If anyone here is divorced and you've never changed your will, and your ex-husband or your ex-wife gets everything in the will, don't necessarily fret. They're stricken by law. They're presumed to have predeceased you, even though they're very much alive. And legally, they're presumed to predecease you. They don't get anything. But that being said, most likely your ex-spouse, if he's still in your will or she's still in your will, is littered all over the place. They're the executor, they're this, they're that. We want to rewrite the will, get that done. Or if you just simply had relatives pass away that are in your will, it's always a good idea to rewrite it. So there's no confusion, just clean everything up. Your will is a living, breathing thing. All of these documents are. Estate planning is not something you just do once and you're good. Right? It's not like getting your rubellum shot when you're 9 and you're good, you're inoculated for life. This is something that's going to change. 3 things are going to change throughout your life. Your finances. If you don't have much, your will doesn't need to be probably super complicated. Later in life, your estate planning might change based on your asset composition. There's the law. That doesn't change much. When it does change, it's usually kind of a shock to the system change, but estate planning is one of those areas of law that if you were a lawyer in 1800 and you were brought forward in time to today, you would recognize the basics of the law today. It'd be a little more complicated, but a lot of the parameters of what estate law doesn't change that much over time, the basics. But what really changes over your life is your family composition. People get divorced, people pass away, people move away, people have fallings out, and you can have a falling out with somebody, it's a sad thing, but we see it. People in their 80s come to my office and say, my daughter and I have had a falling out. I hate to say it, but I don't want her to get anything. Or, I love my daughter, but she married this controlling, psychopath type of guy that if she gets any money, even though it's not legally his, he's going to find a way to spend it. He's going to find a way to manipulate her into using the money for whatever his purposes are. So we might want to do a trust or just take her out of the will. It just depends. So those things happen all the time, and so with that, your estate plan can change.
I have a question for Meghan. I may have misheard, but at one point I thought you said that the will is the master document above any beneficiaries. And then more recently, I thought you said beneficiaries supersede your will.
No, I said you always wanna have your will as a catch-all, just in case
Right.
the beneficiaries aren't there. But your beneficiaries do supersede your will. Yep. But you always have your will. So even if you've got all the ducks in a row, once in a while, one of them likes to go escape. Again, institution changes hands at the last minute, they don't recognize your old beneficiary on it, your will would control that item
You
that
forget.
didn't have it. You forget.
Forget about that small life insurance policy you opened a long time ago, and it's been on autopilot coming out of your bank account, you don't have the beneficiary name, that money will come into your estate and then through your will.
For people about 10 years ago that had MetLife or Prudential in life insurance, they went public. You got a letter that says you can take a cash payout or you can get stock in the company. When I'm doing my Medicaid applications, I'm going through stuff with a fine-tooth comb trying to find things. I'm like, you do know you have stock, right? Do you remember getting that letter? No. And it's such a small amount, like it might be a couple $1,000s, it's still a decent amount of money. But people forget they had it because it's like, oh, I just get a check every once in a while. I didn't know what it was for. I thought it was part of the insurance policy. No, you also have stock out there that we didn't address to add beneficiaries on. So when you own a privately held company and it goes public, they don't pay you out for it. You got stock in that company. Oh, by the way, MetLife got bought out by Bright House. So not only do you have MetLife stock, you now have Bright House stock. We see that so often. So that's why when people come to us, I'm like, well, okay, you got stock, great. Where is it? What is it? Is it already in your like IRA portfolio where it's managed, or do you own individual stock in this company? Because that's gonna change again. Okay, that's great, we have beneficiaries here, but we have to address it here. And again, that's where your will would come in. Oh, I forgot about that. Your will would take care of that small stock that you had.
I think there was a question over there.
Yep, going back to the guardianship, so if you have a minor and 2 living parents, would you recommend still appointing a guardian in the will, or is that not necessary?
You would always want to do it in the event both parents passed away. They went out to dinner together, they were in the car together, an unfortunate accident happened. How we have it in our wills is to say, well, in the event one parent passes away, the other one's still the guardian. But what if tragically something happens to both of us? The other thing to consider too is some people say, well, I want to pick my parents to be my guardian. Well, my parents aren't getting any younger. Maybe my kids are 5 and something happens to me when they're 15. My parents are at the age where they can't handle it. It's just too much for them health-wise. I'm gonna pick another alternate in the event, because even though my parents are alive, they can say, it's too much for me right now, but I put it in my document and said, okay, my parents can't do it, now my brother's gonna handle it. So even though you have 2 parents still there, you still wanna address it, because unfortunately tragedies do happen. In the courts, you don't want the courts to get involved to say, well, I'm gonna pick Dave as, the courts are gonna say, Dave sounds good, he's gonna be the guardian. He's like, I've got enough kids, I can't do
I'm
it.
renouncing now on the record.
Yeah. Good thing I don't got kids. Could have my dog. But the courts might say, well, I'm gonna pick this person. Well, that's not who I would have picked, because they don't have the same ideas of me of how to raise a kid. They already have 14 kids, so I don't want them to be just one of the bunch. So you don't want the court to have to step in to say, well, I'm coming forward with a petition, I'm looking so great on paper, when the kid's going through the most tragic thing in their life, they lost both of their parents. I want them to go with somebody who I know is gonna give them that best quality of life. And the person the court might appoint, you're like, no way.
Actually, this is,
Somebody asked me the other day, well, I'm divorced and I have guardians in my will and my ex-husband has guardians in his will. But if we both die, whose guardians win? It's a race to the end. Whoever's the last to die. If your ex-wife dies, you then have custody of those kids. Then if you die, whoever you've named as guardian is gonna be the person that takes over. So unless you have some other arrangement, either through a divorce or you've added each other, you've had a grandma, grandpa, in a custody order type of thing, there's ways around that. But generally speaking, in the estate planning context, that's what would happen.
One other thing before we switch over to power of attorneys, something else that everybody always asks is, what about the death tax? Are they gonna pay taxes on what they get? Right now in New York State, we have a estate tax threshold of $7.1 million per person. Meaning if you die with an estate, which is any asset that I own, and my estate's worth less than that, my beneficiaries aren't, well, I'm not paying a tax on it. And that would be me paying the tax on it as
The estate
the
doesn't
owner.
pay.
The estate doesn't pay the tax.
The beneficiaries don't pay tax on what they receive either.
In federal, we are at 13.99 million per person. So right now, the estate tax thresholds are so high. So a lot of people always ask, well, what about the death tax? Are they gonna pay it? No. And going back to what Dave said, where we're saying like, well, the executors, they have to take a commission. If they take a commission, they have to pay taxes on it. That's another reason a lot of people waive it, is because, well, if I just take it as the beneficiary, I'm not paying tax on that.
Yeah.
Versus if I take my executor's commission, I'm paying income tax on that. So that's a consideration, because everyone was asking, what about that death tax? The threshold is so high right now. And again, that's per person, so even if you're in a spousal situation, each one of you has either a 7.1 million or 13.99 million. And that number goes up every year for inflation a little bit.
Tax rate, cost basis.
There's also a step up for tax bases at your death. Meaning if you died owning an asset in your name, we always go with the house example. I know this is not what everyone's house is worth, but sometimes just math is being easier. So you bought your house for $50,000. At death, it's now worth $200,000. Dave, as my executor, goes to sell it. For his tax basis, meaning what we would have to pay tax on when we sold it, he gets a step up in tax purposes to what it was valued at the date of my death. So if Dave sells it for $210,000, the capital gain's only on the $10,000, not going all the way back to the $50,000 that I bought it for. And that applies for any asset too. If you have a retirement account, if you have stock, it goes to the value of the date of death, not the date you bought it for. So if you had old Apple stock that appreciated or anything like that, the tax basis is at death.
Did you say that was based on assessment? So
It's full market value.
appraisal? Oh, okay, so if
Yep, full
That's
market
where it
value.
gets
it's on the market for 200,000, you sell it for 260?
That's
Are
what
you
it's
paying
worth.
tax on the 60 or on
The 60,
just on the 60?
not on the what I bought it for at the 50.
If you're selling it,
No, so what I'm saying is,
So if I inherit the house, right? Mom and dad bought it for $50,000, I inherit it. If I turn around and sell it immediately, that's gonna determine the value. The date of death value, we're gonna use what it sold for a couple months later. If I inherit the house and I rent it out for a few years and then I sell it for $260,000, I'm gonna pay tax on whatever the difference is, in this example, $60,000 between, if I took it. If you inherit an asset and you plan on keeping it, it's always a smart idea to get it appraised right after death. What is it worth? Otherwise, we're stuck arguing the assessed value. We all know that's not really the value, but it's close. Get it appraised, stick that appraisal in your file, and when you go to sell that item, you've got a contemporaneous appraisal showing what it's worth. So if the IRS fights with you about it, you can show them, I had this house appraised in 2025 when my mom died, and now I'm selling it in 2030, so I can prove what the appreciation is. Or if it's stock's a little easier, you just log in and see what the value was on the day mom died of your Apple stock, and we know what it was worth that day. So, but that's just something that you want to do if you find yourself in that situation. People get we have this internet, right? And it's a wonderful, beautiful thing. But people go online and they scare the heck out of themselves reading stuff from other states, reading laws from 12 years ago. Their uncle's brother's former roommate told them that they have to pay tax on everything they inherit because he's an estate lawyer. He's actually not an estate lawyer. So there's a lot of things out there that you hear, and that's why we always advise, whether it's us or any other attorney, talk to an attorney before you make any decisions, because they'll be able to give you the best answers.
The example you just gave, bought it for $50,000, die, leave it to the beneficiary, get it appraised $210,000, you keep it, sell it for $250,000, tax on $40,000.
Right.
Okay.
Exactly. It's called a step up. Your basic, stop me if I'm boring you, but boring myself. your basis of anything is just what did you pay for it? You know, if I bought this coffee for $1, my basis is $1. If I sell it to her for $2, then I made $1. That's my gain. In an estate, you step up the basis. Whatever your family member that left you something bought it for, doesn't matter, because you're going to take it at its present value. And that's one way the government tries to encourage asset growth and leaving things down the line, because there's such a tax benefit to leaving something to the next generation, and they take it at what it's worth at that time, and when they sell it, they don't pay tax. Canada Lake's a perfect example of this. You've got people, we're getting to the end of the line with those folks that bought those places in the 1940s for $12,000, and now it's worth $750,000. If they just sell that, they're going to pay a lot of tax. And this is basically all gain. But with a family, when they inherit it, they turn around and sell it because they probably can't afford the property taxes. We see that quite a bit. But they don't have to pay tax going all the way back to 1947 when the property was bought for dirt cheap. You know, so it's a way to encourage assets staying in the family, building wealth, et cetera, et cetera, et cetera.
How much time do you have before you get it, have it appraised and sell it, before you have to either pay for the short difference or the larger one? Is there a time limit?
Not a particular time limit. It's more of a gray zone on, yeah, if you inherit that house and you turn around and 3 months later you sell it, I think the IRS is going to give you a problem. 9 months, a year later, they might want to have another valuation look at it. 7 years later, they're definitely like, no, we're not using the value that you say it's worth.
So, if you inherit property, do you go to a bank or do you go to real estate for the assessment?
For the appraisal?
Appraisal.
There's separate independent appraisal companies that's all that they do. They go out and appraise properties. You can do a real estate agent sometimes, but sometimes the IRS is like, well, they're just giving you like a comparative, where if you hire an appraiser, they're coming in saying, this is the value of the house based upon the market, based upon what I've gone into the house and seen, and they're gonna give you more of an accurate one, and that's the one that's been most accepted and not challenged by the IRS or even New York State. That's always been the best case, and they're independent, and there's a bunch of them around all the areas.
Question regarding houses, since you're talking about that. If the home is jointly owned by spouses and it's not covered in a will, what happens then? And is it the value going up? Is that stopped at that $50,000?
No, in the event, so say both spouses own it, they took it as husband and wife, one spouse dies, now the other one owns it solely. They get a step up for half the property value at the date of the first spouse's death, up to $250,000, because that's our capital gain exemption that it is currently. At the death of the second spouse, as long as the property hasn't appreciated a lot more, the step up would be at the second spouse's death. Now, if there was nobody else on the deed, then your will would control who would get it. And that would be the basis is the date of the second spouse death.
So if when the first spouse dies, is that you need to get an assessment then too?
No.
No. How do you determine that step up then?
It's an automatic $250,000 step up.
Oh.
Automatic.
And if you don't have
Between
a will,
spouses.
and then the second spouse dies, what happens to that property?
It depends. So if you don't have a will, it would go with like through intestacy law. So that's where the state determines. So if you have kids, it'd be split evenly between your kids. If you don't have children, it goes back up your family tree. So are your parents alive? If not, then it goes to your siblings. If any of your siblings are deceased, it passes down to your nieces or nephews. So to always find somebody, but that might not be the person that you want to receive your assets. So that's where the will comes in to say, well, I understand it, go back up this convoluted tree. We also don't know where cousin Johnny is, but I gotta find him.
The table of consanguinity.
Yeah.
So it sounds like your financial assets, as long as you have them covered with beneficiaries, you're pretty much okay. But your house, you really need to get, and your personal physical property needs to be covered in a will.
Yep, will or a trust, which we'll get to a trust in a minute. I know there's one other.
Yeah, it was just somebody, I think it was on the right. Ma'am, did you have a question?
Yeah, not to confuse matters or get into detail, but so just for the cost basis, so those are only assets that are non-retirement assets, right? So if you have individual Apple stock in a brokerage account, that's gonna get stepped up. If you have an Apple stock in an IRA, that's not gonna get stepped up because of tax, completely different tax bucket.
No,
It's on the record. For IRAs, you would just pay tax on any gain when you take it out. Because the IRS has said, we've been so generous with IRAs, 401ks, to not tax you when you put it in. Roths are a little bit different, that's post-tax. But for typical IRAs and 401ks, you would get a step up. But you would just pay tax on any additional gain when you take it out. Or whoever your beneficiary is.
Yeah, as ordinary, yeah, income.
Yes.
Right, if you're doing
Yep, so you would
distributions.
just, on that.
Yeah?
A question about going up the tree. So, we unfortunately got together, that's my whole thing. And he has a stepson. How's the tree work?
Did you adopt a stepson? He's not on the tree. Stepchildren receive nothing unless you give it to them. They are not legally related. I know it sounds weird, you're married to someone and you have a stepson. Unless you make a distribution to them in your will, they're not entitled to receive. There's a list in intestacy called distributees. Distributees are the people that would inherit if you don't have a will. As Meghan has said, the state has a plan for you. I sound like Soviet Russia saying that. But state has a plan. It's a backup plan if you don't have a will. Under intestacy, there's a list. Your distributees are those people that would inherit at the time of your death if there was no will. Your stepchildren are not on that list. They're not on the table of consanguinity, it's called. It's a chart, and Google it online, and it will show you how you relate. What is a third cousin once removed? And then you go over, up and down, your aunt and uncle, and I don't know. Now, it's not super important to know because it rarely happens, but is it 8 levels they go, 7 or 8 levels they go? If you were to die with no will, and you went out 7 spots on that chart, and there was no one, there's no relative left, everything would demure to New York State. New York State would inherit your estate because there's no one left on the chart to inherit. Another reason that if you feel strongly about leaving money to a charity or a friend or a random stranger, whatever you want to do, you don't want New York State to take your money. In the off chance that you were to die with no one left on the chart, you don't want it to go to New York State, I'm guessing.
On the chart, do you want the cousins and so on, or no?
Yeah, it goes up to cousins and second cousins and, then your cousin's children and the spider the web wants to find someone alive that you're related to leave the money to. But
We have to look for them. Like, they make us try to find them. We've had to hire private investigators to try to find these people. I had someone who was like, during the true case, Russian Revolution came over, couldn't find the family. It took us probably a good 3 years to try till we knew there was somebody somewhere, and the courts want to have, how did you try to find these people? It took us 3 years to finally find somebody, because again, the family, we don't know. Well, pretty much. But we have to do a good, diligent effort to try to find these people. Well, I haven't talked to cousin Johnny in 20 years. Nobody knows where they live. They live off the grid in Alaska. Still gotta find him. We still gotta serve him with paperwork.
I found a daughter in Argentina,
Yeah.
but
it can be amazing how quickly people that don't want to be found come out of the woodwork when they hear this woman hadn't seen her father in 40 years and he felt that it was my daughter, she should get something, even though she doesn't treat me very well. And somehow it made it through the family ranks of email chains that there's money for you, and she flew back here from Argentina and signed paperwork. So I did have one though recently where we knew where she was. She was in Ontario County, somewhere. And it was a sister that hated her sisters, didn't want to help them at all. And she just wouldn't tell us her address. We knew she was here, we know she's alive, she's emailing us, but she's like, I'm not going to tell you where I live because I don't want you to know where I live. And we're like, man, we have paperwork, we have to get to you for the estate, or we can't move forward. She said, nope, not doing it. We hired a private investigator, finally found her, but we had to serve with a citation, we had to publish in the newspaper. It just dragged things out, and everyone's mad, and everyone's upset, and meanwhile the house is rotting away because we can't get anybody appointed to deal with it. So once in a while, you just get bad blood. I'm sure you've all heard or experienced those stories. And when I was in law school, I'm like, this is, estate planning sounds not a lot of drama. It's just free money. And I'm like, oh, my uncle died, and I'm in here $1 million. No, not the case. There's more drama in the estates. And what's really strange is more drama in the estates that I have that are not that big. It's not that much money. I mean, a $4 million estate, everybody's just kind of like, okay, well, we're gonna get along. And the $50,000 estates, like knives are out, you know?
Mom borrowed $10, you
Yeah,
borrowed
yeah,
$10
yeah,
from
yeah,
mom 20 years ago, and
I-
now you need
yeah.
that.
I wanted, yeah, there's 3 guns, and we're gonna fight over one of the guns, because it was dad's favorite, like, okay. Yeah, oh,
Oh, she is.
I have a lot of friends who have changed the deed on their house to their children or whoever. Is that a beneficial thing to do, or don't you suggest that?
that's probably a good segue into trusts and Medicaid. Do you wanna start with that?
Did you have a question on what we were just finishing up with?
It's just a follow-up on the house thing. So let's say a house has been jointly owned for 50 years by a husband and wife, the husband dies, the wife inherits. You said only a $250,000 step up, but in that period of time, the house value could be a lot more.
You also have one too at your death. You have an additional $250,000
But I have to
exemption.
keep the house.
No. Even if you sell it, you still get that exemption for capital gains purposes. So even if you sell it while you're alive, that exemption stays with you. You either get it in life,
You mean
or
no capital gain tax on that house?
unless it's one of like the lake properties that went from $10,000 to $1 million.
If during
If
But
during
only
lifetime.
250, what you're saying is only 250,000 is, that's the value of the house that's not taxed, no matter how much it's worth now.
No, not necessarily. There's a lot of factors that go into capital gains. You get an automatic on your primary house, each spouse gets $250. But you can always negate capital gains with improvements. I put in a new furnace, I put on a new roof, I put in a new driveway, I put on an addition. So you keep records because you can argue, well, my assessment and the value went up because I put this addition on, because I added this. So there's other ways to negate any kind of capital gain that you might have. So if you've done some big improvements, just keep records of it. Because that's what we use. So in addition to the statute one that you have with the $250 each, you also can negate it through the improvements that you made on the property.
If you're selling it.
But you can't have it assessed. I mean, that doesn't affect, improve the step up.
The assessment is different than like the full market. So the assessment is, you get the person who drives by, oh, the appraisal you mean?
Yeah, I'm sorry.
So you don't, if you're putting it on the open market, that is what they determine as the full market value. So if you're selling it while you're alive, that's the value that it is. We use the appraisal more when somebody passes away. If we want to maintain this house, because it's a lake property that's gone up in value significantly, between all of us siblings, we want to keep it, and we're going to split the taxes, so we're going to keep this for a lot more years, and the likelihood of lakefront property decreasing in value is 0. So we're gonna get an appraisal at the second one of our parents to die, just so we can establish what that basis is and keep it in our back pocket. So if 10 years from now we go to sell, and if we had it appraised for $750 and now we're selling for $1 million, mom and dad bought it at 10, we can say, hey IRS, as soon as the second parent died, we got it appraised for $750, this is what our basis is. So we would only pay capital gain on the above. The reason you do it is because 7 years from now that lakefront's worth $250,000 more, you're gonna get in a fight with the IRS because you say, well, how can you determine what it was 7 years ago? We don't know what it was, we're gonna say it was higher. So just by getting that done at the second death, if you're gonna keep it, like Dave said, if you're gonna sell it within a couple months, the full market value that you sell it for on the open market, that will be what the value is. But if you're keeping it for a while, that's where the appraisal comes into play. Did that answer your question?
Well, I meant between husband and wife, you know.
There's nothing really between husband and wife like that, because you guys get unlimited exemptions and gifting between each other, so you're not paying tax when one spouse dies.
Okay, that's all.
As long as you jointly own, there's no tax until a sale. The only time you get
But the value of
taxed,
the house is now $250, no matter if it's worth $550.
you get that automatic exemption, yes. At the first spouse to die, yes, you get that automatic step up.
But I'm saying the house is worth a lot more than $250, you still have to pay tax there, about $250.
For confusion,
But-
it's a step up.
But what did
Not
you
the
get?
value.
Yeah.
Well, let me ask you this, in your scenario, are you selling the house while you're alive,
I
or,
don't know,
after your death, the step up is
it
whatever the
doesn't
value
matter.
is? It doesn't matter, right?
The value from what you bought the house for to what you sell it for would have to be greater than $500,000 total. So if you bought the house for $250 and you sell for $400, which is kind of common in this market, you're not paying capital gains tax. Because you're within that $500,000 bounds. Yeah,
It's on profit.
correct. So there's a lot of exemptions. So the likelihood, like I said, unless you have like those big properties, you're not gonna pay a capital gain tax on your primary residence.
It's extremely rare that anyone pays capital gains tax on the sale of their primary residence.
Okay.
Okay.
So she had asked about transferring that house into the kids' names, basically, which is a common tool in estate planning practice. But the question is, why would we want to do that?
It's kind of a twofold. So when people come in, they go, well, I also want to protect my assets in the event I ever have to go into a nursing home. And I want the other added benefit of avoiding probate. One of the tools that we use, and again, it really depends on what your assets are. Some people, I don't have retirement, I don't have much money in my bank account, I just have my house as my primary asset. So we do what's called a quick claim deed in that case, because they're saying, well, I want to protect my house, and I also want it to seamlessly transition to my kids on my death. Now, a little bit of background on Medicaid. Right now, under the current Medicaid rules, meaning you go into a nursing home, and you have to pay for your stay there. Average nursing home in central New York is between $13,000 and $21,000 per month. It's a lot of money. So you're either private paying that rate, you have long-term care insurance, which not a lot of people have because it can get expensive, or you have to apply for Medicaid benefits. Medicaid is qualified as a poverty program, so in order to qualify, you must have certain asset requirements. Right now, under the current laws, if you are a single person, you're allowed $32,000 cash. If you're a spousal couple, you're allowed about $105,000 cash. When I say cash, that's bank accounts, that's additional property. You're also allowed one house and one car. For either scenario, retirement money, qualified accounts, IRAs, 401ks, whatever the principal value of that is, does not count towards that $32,000 or $105,000. That's treated as income. The reason being, if Medicaid were to force you to cash it in, you're gonna lose almost half the taxes. So they strictly treat IRAs and 401ks as an income stream. But they will count cash values on life insurance policies, values of house. Now, anytime that we do planning, I don't go best case scenario, which is the nice $105,000, the spouse gets a house and a car. Because typically that's not what happens. It's the spouse passes away, they were the one keeping the other spouse home. They were the primary caretaker. Now that other spouse can't stay home, so now we're dealing with, you're only allowed $32,000. Part of that plan is Medicaid has what's called a 5-year look-back period. So they're auditing your assets from the day you want to apply for coverage 5 years back. They're looking for gifts. Did you give any assets away to be able to qualify for Medicaid? So doing the house, that's one way to do it. So what we do, like I said, is called a quick claim deed. So you transfer the ownership to whoever you want. It could be kids, it could be nieces, nephews, it could be me. Just kidding. If you're really feeling it, no. And what we leave you with is called a life estate. So legally, you still own the house while you're alive. Why do we do that? We want you to keep your STAR exemption, or that enhanced STAR, or that VA benefit you're getting on your school taxes. We don't want you to lose that. Also, it's still your house. We don't want somebody to be able to sell it out from under you while you're alive. So, you maintain the life estate and you pick who owns what's called a remainder interest in your house. Upon you passing away, your life estate extinguishes and whoever you have named now owns the property. If that deed had been done 5 years before you need to apply for Medicaid, they cannot touch your house. Life estates do not have a value for Medicaid purposes. Yes?
Okay, so I was wanting to ask about a trigger event for completing this deed document that you're talking about. So what I think I just heard you say is that if you put in place this deed arrangement within that 5-year look-back period, then it doesn't get counted as an...
If it's outside the 5 years.
Oh, outside?
Yeah.
So actually, it's important to preempt
Yes.
Correct.
when you think you might be reaching that point where the house could be
Yeah.
an asset that could be counted against you.
What they're gonna do is the day you apply for Medicaid, they're gonna look back 5 years. So they're gonna turn the calendar back 5 years. Anything that happened before 5 years is the safe zone. You transfer the house to the kids, you put everything in a trust. We're gonna talk about trust, we're gonna talk about irrevocable Medicaid trusts. But it's not gonna matter if it happened within the 5 years, like the red zone, right, in football. If you're within the red zone in the 5 years, it's gonna count against you. If you're outside of the 5 years, you're gonna be safe. So you've gotta get all these things done in advance of that, not 2 weeks before you need to go into the nursing home, because there's still some things that Meghan can do, but Meghan does more than Medicaid than I do. But it's not gonna help if you do the transfer 2 years before you go to nursing home.
That's the reason why I'm here today. So my father is 80, he refused to sign documents over because he's an old gentleman and just refused to do it.
Yeah.
Well now, so we have 20 acres of land in a house, and he's at the hospital right now, waiting for a room to open up for care. And I'm trying to find a way around of him losing everything.
Right.
And I don't know if there is a way of doing that.
There could be.
Because I want people in here to, if you have assets that you
Does
need
he
to
live alone?
do, that you should
Not married?
really do that. Widow.
Widow.
So I'm the only child,
What other assets does he have?
just the house and the property and a small life insurance policy.
Is someone willing to buy the parcels? Like, does someone have the means to buy it?
In the family, it would be just me, and is it fair market value?
Yep, it'd be fair market value. So what can be done? There's always a way to save some. Nobody does any planning. There's always a way around it or how we can do it. So what we normally do is when selling to a family member specifically, Medicaid is very, 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 I cannot emphasize this enough, persnickety on how you do it. What we do is we get an appraisal for the properties. If someone in the family is able to purchase it, we purchase it for that appraised value, because we don't want to go on the market, we don't want to have a realtor, because then we're paying realtors commissions, we don't want to get into that. So as long as we sell it for the appraised value to a family member, Medicaid's okay with that. So you give dad the cash, you get the properties. Now, say the property, I'm just going with a number, I know this is not the case, but say now dad's sitting on $100,000 cash. Meghan, you said he's only allowed $32,000. There's a way we can spend that money down. Does he have a prepaid funeral? No? We can go prepay his funeral with that extra money that he has. Okay, he's still got some extra. There's a tool that we use that's applicable and accepted by New York State called a promissory note. So what we do is it's called a gift and loan strategy. So say he's above, again, I'm just doing even numbers, he's above by $100,000. By gifting part of that money away, we create a penalty. So say we gift, right now it's for every $11,727 we gift away, we have to private pay 1 month at the nursing home. So based on his income and a formula and the assets that he has, so the money you paid him for the value of those properties, I'm gonna say we're gonna gift away half of that money and use the other half that he owns to pay the penalty. It's accepted by Medicaid. So there's always a way we can save some depending on the circumstances. So it's not all is lost, there is something that can be done.
Can it be a grandchild?
It could be anybody.
Family.
Yeah, any family member, any
Has to be a
third
family
party.
member?
No, it doesn't have to.
Oh, okay.
It does not have to be. It can be anybody. You can get on Medicaid though and still own a house. So if you've
Well, he's
done,
on Medicaid now, yeah.
Yeah, so if you've done zero planning and you own a house, you can still be approved. What Medicaid's gonna do though, is they're gonna put a lien against the house. For however much money they paid out for your care, again, we're talking average $15,000 a month, they're gonna put a lien on your house. If you sell it for $200,000, Medicaid's gonna go, hands out, I paid $120,000 towards dad's care, I get that before you get the rest of it. But there is stuff that can be done, especially for, this has been a family house, this has been in the family for generations, how can we keep it? That's the way that we would do it. Get an appraisal, have them buy it for the appraised value, and then there's a way we can work around with the money depending on how much it is.
So what happens if it's already moved forward, let's say he gets placement into a nursing home? Can this still be worked on as, even though he's been approved and been put in place somewhere?
Yes.
Okay.
We would want to move quickly,
Yep.
but what we would do is a lot of times they would apply for Medicaid, so we'd say, no, don't apply right now. So we'd be under a private pay scenario. But it's kind of worth it to say, well, we might private pay 2 months because we're gonna protect these extra assets. So we're gonna come in under private pay. Again, we don't have to pay them right this second. We're saying we're selling the house, you're gonna get your money there. After paying off the 2 months of private pay, then we're utilizing the promissory note to take care of the rest. And then once the promissory note is done, paying off the penalty, in the meantime, I've already applied for Medicaid. Medicaid's approved our strategy, then they're approved for Medicaid as soon as that time period is done. So there is a way to always do something, even if somebody hasn't planned. The other exception, if they have a disabled child, we can transfer assets to a disabled child penalty-free. If a child has lived with that parent for more than 2 years, we can transfer the house to that child. That was their primary residence, that's where they file taxes. I just did this on a Medicaid recently. Kids lived with the parents for 40 years. I can transfer the house to him the day dad needs Medicaid, penalty-free.
Because the government says, you've provided care by living with dad, living with mom, you've kept them off of the taxpayer rolls, off of Medicaid. So we're gonna allow you to keep the house, it's not gonna count against your application. It's a frustrating system. When we're young, our society says, work hard and save for the future. And then when you get to the future, our society says, well, we were just kidding about that. Did you actually get assets? No, give those away. Or we're gonna take them from you. It's a very frustrating system that leaves us, as Meghan was saying, doing all of these complicated, balancing act of trying to get assets out of your name, still have some semblance of control over them. And that's one of the things I've seen in my practice is it's easy enough to write a deed and say, I'll put the property in my 3 kids' names, and okay, great. But then what you don't know is that Johnny or Sally has a bunch of credit card debt and they get judgments against them, and now those judgments are against the house that you're living in. Or they get sued for some accident. And so while for Medicaid purposes, and that's why this is all an art, not a science. There is no one cookie cutter fits all, otherwise there wouldn't be attorneys in courts. You just fill out the paperwork and you'd be done. It's the art of crafting something that works for each individual case, because we just don't, the circumstances are very unique. Like you were just talking about your family circumstances, and it is unfortunate. I've seen a lot of clients who they don't want to give up the control. It's my house. I don't want to put my kids' names. Well, yeah, but you're reserving life use. You're the only one that can live there. Your kids don't even though they own the house, they own the future right to the house. They can't even go there technically, but people don't want to give up that control. And I did have a woman once, and this is, sometimes it can backfire. We put the house in the kids' names, and then a couple of years later, mom decided, I go to Florida in the winter, and I want to stay there. I don't want to come back up to New York. All my friends are down there in my community and whatnot. And she said, I want to sell the house and take the money and go buy a bigger place in Florida. I want to spend the whole year on it. And the kids were like, but mom, we need to sign off on that because the deed's in our name. She's like, well, yeah, then sign it. It's mine. We'll know the deed's in your name, guys, but it's my house, kids. And they were like, but mom, who's going to care for you as you get older down there and we're not down there? It became a big fight. And mom's like, sell the house so I can move. And the kids said, no. We're not going to do it because we think you're making a bad decision because we're not there to provide care for you as you age. you know? And that is something that can happen because you lose control. You do. I mean, you can't just decide you want to sell the house anymore because the kids have to sign the deed, and if there's an issue, that can create a problem. That's true. You can't.
The other scenario is you deed it to the kids and they sell the house and you got them move out.
They can't, if you have
Not if you have a life.
if you have a life use, they cannot sell it without your permission.
But if you deed it to the kids,
You maintain, how we do ours, how we do our deeds, I would never have you, if that's your primary house, I would not do it.
I've actually seen this in the past.
So, I'll be honest with you, I have seen it too. You get
Some
general
experts like that.
practitioners, somebody didn't do it right, how we do our deeds, you get, and I point out the language, I'm like, this is what gives you your life estate, the right to use, pay for taxes. We also give you something called a power of appointment. What that power of appointment says, so okay, I named my 3 kids as the beneficiaries on it. By having that power of appointment, I can change who that is at any point in the future. So my son Johnny gets in trouble and files for bankruptcy, I can take his name off the deed. The control still rests with me while I'm alive because it doesn't vest. They don't completely own it until I die.
Sticks. Use that as an example.
I'm 90 years old, so in the past, I've seen this happen.
Mhm.
In the past, and I'm talking years ago now,
Absolutely.
where the parents, I guess, I don't say deeded, but supposedly sold it to them somehow, however they worked it. And after several years, the children sell the house and the parents have to move out.
Unfortunately, that has
That has happened.
And that's where it's key on,
And that's poor planning.
and that's poor planning.
Oh, I'm sure,
When it comes to real property, real estate, they call it the bundle of sticks. I don't know if anyone's ever heard that concept before. These are all the rights that can exist to property. And what we're doing essentially is we're saying, we're gonna give my kids these rights, the future ownership, the deeds in their name. But in the deed, I'm reserving 2 things. My right to still live here until I die, and my right to make certain limited appointments in the future of where the property may go. And then upon your death, those rights all transfer to the kids. They have everything and they can sell it. And there's different rights you can reserve within your deed. You still, like we say, I transfer my house to my kids and I reserve life use. I'm responsible for the maintenance, upkeep, I'm responsible for the taxes, I still get the star exemption because I'm the one living there. I have the right to live in the house and my kids don't, even though and if they step on the property, I can have them arrested for trespass, even though they're on the deed, because they don't have the right to be there. I do, even though they own it. So you can step all over the yard the day I die, but not before, if I say so.
Okay, what happens if they're declared not able to look after themselves and they still insist on staying there?
The person who's reserved the life use,
Yes.
that's gonna depend on where they're at, basically. Typically, we say, it's a little more complicated than that. Typically, we say life use until I die, I decide to move out, or I'm no longer able to reside there for a period of, what do we usually say? No expectation of return. I've gone to a nursing home now, there's no expectation of me ever returning. At that point, my life is the stable
And
established.
they refuse to go to the nursing home.
That's where you have a power of attorney. So sometimes you have to get the courts involved, and sometimes when you have a power of attorney, which is a person who can make financial decisions for you while you're alive, can step in to help replace you. So it's really situational. It depends on what's kind of going on. I think we would be remiss because New York State, as of last year, also instituted a deed that's called a beneficiary deed. So it means I'm gonna put it on, it's like putting a beneficiary on a bank account, on a retirement. That kind of a deed, though, does not give you any protection from a nursing home. All it says is, in the event I die, this is who gets it. So you do a deed transferring ownership to your 3 kids. Because you still own 100% of it, that will not give you protection from a nursing home. It's new in New York State, so we get a lot of questions, well, I want to do this deed. I'm like, again, like I kind of said in the beginning, that's why we always ask you, well, what is your goal? Is your goal to protect your assets from a nursing home? That deed will not get it for you. The life estate deed where you give your kids the remainder interest, that will. That'll avoid probate and pass to your kids upon death, and it'll start the 5-year look back in the event you ever go into a nursing home. I see you got a question.
That was one of my questions on the transfer on death, so it doesn't protect you from that. But I have another question from his, like when you can give that money away, I'm confused about the 5-year look back and they're looking for gifts. How can you give the money away if they're looking?
You have to use that promissory note tool. So you go into Medicaid saying, I recognize that we are gifting away. We do it at the same time. The gift and the loan are made at the same time. It's kind of complicated, but Dave's my child, I'm in the nursing home. So what Dave's gonna do and come in and say, Megan's got $200,000. Utilizing the promissory note, he's gonna transfer $100,000 to one account in his name, $100,000 to another account. He's signing a promissory note to me to say, for the $100,000 gift that I made, that we're gonna get a penalty with the nursing home, I'm promising to pay back with the other $100,000 that I have, that gift. Medicaid allows that. We're acknowledging to Medicaid, yes, I made the gift, but I'm paying it back with the other part of your money. It's a way that they're saying, we understand not everybody's done planning. Here's how you can save a little bit. So it's a strategy that, as soon as we do that, I'm applying for Medicaid that same month with the local Department of Social Services. It's county-wide, so Ontario County, you apply with Ontario County Department of Social Services. I say, this is what we did strategy-wise, this is how we came to our figures, and they say, okay, we agree with your penalty. We agree with the strategy that you did. You can't just gift the money to Dave and then have him hold on to it. It has to be through this promissory note strategy. Yes?
So, in my experience, there's a lot of people that they're forced to scramble with a Medicaid application because of, health issues pop up and people haven't done planning. So, in a best case scenarios, we've got people here who are interested in strategizing and thinking carefully about how to prevent some of the mistakes that you've talked about. About how long does it take from start to finish with a Medicaid application? About how much does it cost? Or is it very specific to an individual situation? And is there any benefit to starting that process ahead of like a crisis moment?
So what I typically do, if someone's like, well, mom's home, they're not doing very well, the likelihood of us escalating to the next level is great. We have a list of documents that Medicaid requires, permanent documents, marriage certificates, birth certificates, driver's license. We're gonna need 5 years of tax returns. So we provide them with this list so they can start, because let's face it, you're trying to go through somebody else's stuff to find it. It's gonna take more than a couple days. So this is gonna allow them to start doing that process, to try to get some of these assets, this stuff together. The other thing that, from the moment you enter a nursing home, you technically have 3 months to apply for Medicaid. So if I go in June 1st, I have until September 30th to apply for Medicaid benefits, and it'll be retroactive back. I'll be honest with you, I put an application in recently, probably in February. We're close to a decision right now. The problem is the counties are overworked and understaffed. So a lot of it is not so much you don't have the documents, the county just takes a little bit of time because they're going through hundreds of applications and they've got 3 people. Now, even if it takes, I come more from, like I said, Onondaga County, where the plethora is high, Monroe County, bigger counties, more nursing homes, it's a lot more. It could take a year to be approved for Medicaid. However, if I applied on that February date and I get approved February 2026, it's retroactive. The important thing is the date you get your application in. Even if you don't have everything, getting just even the basic form signed, here's my name, here's the signature, you know I'm applying, getting that in starts that when I can get eligible for benefits. So it really depends. So we always say, well, okay, this is coming. Here's how you can start hedging your bets. This is what you need to look for. This is what we're gonna have to start getting. get us recent bank statements, because as part of what we do, if we do Medicaid applications, I'm the one, and we're the ones auditing your bank accounts. Is there any surprises out here? Did you gift cousin Johnny $50,000 2 years ago? That's gonna come back at us later. How can we address that? How can we handle it? So we're going through the bank statements, we're helping get records. There's really not much that I can't find. I've been doing Medicaid for my entire practice of 13 years. We know where to go. We know how to get, well, you need to get tax returns. I don't know where their taxes is. There's a way to get them. There's always a way to get them.
Regarding Medicaid, and getting placement in a nursing home when there are very few beds available, if one does not have cash to pay for private care, it's less likely, honest, to be placed in a nursing home that you want you or your family to be in.
Sometimes yes. But just because I could not get into this place and I got placed somewhere else, does not mean down the line you can't transfer to that one. I have seen it happen where they didn't have a bed, so I had to go into XYZ nursing home, but I still had an application in at the other one. Medicaid will transfer wherever you go.
But still, if you don't have cash to.
Not always.
Real
It's
estate
not as
prices.
prohibitive. No, I'll be honest, that's more for assisted living. I've seen that more be prohibitive with that because you can't get Medicaid for assisted living. That's always private pay out of pocket, usually around $6,000 a month. Assisted living, yes. They want to see what cash you have. Sometimes what we've used as a strategy, somebody who hasn't planned, we're gonna private pay 1 month just to get you in, then we're applying for Medicaid after.
Yeah.
Sometimes you pay a month to get in the door. It really depends.
Just want to make a comment on your question, Maria. I get this question, when should I start planning for this? And that is such a difficult question to begin to answer. You may never need Medicaid. You may simply never need it. You might get hit by a truck tomorrow. It may not exist, or the form that it's in is changing constantly. We just don't know. We just don't know. There is no, obviously, sooner than later. The best answer is, 5 years before you need Medicaid is when you should do the planning, but we don't know when that date's gonna be, if ever. So it is just a very difficult thing. Your health is gonna dictate a lot of that, obviously. Your living circumstances, if you have an adult child living with you for years, you're less likely to have to worry about the home than if you don't, providing care when you need it. It's a very difficult thing to know when to plan and what to do. And I think that is a good time to switch to talking about trust. Okay. Yeah.
I think my question was, this has nothing to do with Medicaid or anything like, can we deed our house to like our 3 children? Can we just sign a deed over to the 3 children? They don't live with us or anything. Does that have to be under a revocable trust?
You can simply deed the property to the kids, like we've been talking about. We do a deed that puts the property, the future interest in the property in their name, and then you would reserve life use. So you can live there for the rest of your life if you choose, and the kids get it. As far as Medicaid goes, as long as you live there, as long as that's happened 5 years ago, it doesn't count against you for Medicaid. Another option is to deed the property to a trust. Still, as far as Medicaid goes, same rule. It still that transfer has to happen outside of 5 years for it not to count. But once the 5 years have gone, it's in the trust, it's not touchable. Now, you can transfer it to the irrevocable trust and still, that's not into the kids' names, that's in the name of the trust. And I think that's a good way to segue into trusts. What are trusts? Trusts is when you put money into an entity where you have a trustee, the person that manages the money. And then you have a beneficiary, the person that gets the money. As long as all 3 of those people, the person establishing the trust, or the grantor, the trustee, and the beneficiary are not the same person, then you've got a valid trust. If it's all the same person, it gets disregarded. You can't be the one that puts the money into the trust, manages the trust, and you're the only beneficiary of the trust. Otherwise, it's just you living your own life, and the trust doesn't count. There's generally speaking, two types of trusts, irrevocable and irrevocable, and then under those umbrellas, there's a million different types of trusts that we can do. A revocable living trust, generally speaking, is you put your assets in the trust, you don't own it anymore. The trust owns it. You may be the trustee, and most likely you are going to be the trustee of a revocable living trust. What are the benefits of a revocable living trust? Number one, it avoids probate. That's the number one reason. Revocable living trusts, generally speaking, were a legal concept that started in California. The population of California is very large, and the probate courts were very far behind. And so some very smart lawyers said, I got an idea. You only probate what you own in your name at the time of your death. But what if we created these trusts, and we've had people put everything in the trust? So instead of Dave Whitcomb owning it, it's Dave Whitcomb, trustee of the Dave Whitcomb Trust. Then Dave Whitcomb doesn't own anything, so we don't have to go to probate. We just go around it. And that was really the only real benefit, was just to avoid probate. People talk about probate like it's terrifyingly scary. You gotta go to Dracula's castle to get your will probated. It's not that bad. There are actually benefits to probate. Number one, you've got a judge overseeing everything, making sure that things are done correctly. Number two, if there's issues, you've got the court right there readily available to help you deal with those issues. I've got a case right now. There was a brother that we believe took money from an account. We filed motions in the surrogate court to try to recoup those monies. They should have been estate assets that were divided amongst all the kids. He just took it. His position is, well, Mom wanted me to have that money. We'll let the court decide. But because we probated that will, we've got the judge right there. We got the court clerks right there. We've got the ability to enforce things that we want to enforce in the estate. It's not as lengthy of a process as people think. Negatives of probate are sometimes it can be timely, sometimes it can cost a lot of money, but what I found is whether it's probate or not, whether your money's in a trust and there's an issue, or whether your money's not in a trust and there's an issue, there's still an issue. And you're gonna end up having an attorney fight about that issue one way or the other. And if there's if you're not in probate, you're not in surrogate court, you're gonna end up in some other court probably to fight about that issue. So I think, generally speaking, you'll hear attorneys try to scare you with probate. Oh God, you don't want to do that. It's terrible. But that's just a way to sell you a trust. Because I can charge you, I'll be honest, if you all want to get revocable trust, we'll do it. You probably don't need it, but I'll make a lot more money if I sell it to you, know? And then when you die, your kids aren't gonna understand the trust anyway, and they're gonna hire us to help them do the trust, and we'll probably make even more money. But that's not our goal. Our goal is not to just sell you something you don't need. Now, there are circumstances where a revocable living trust might make sense. One of the nice things about a trust, your estate is a public document. Any one of us can walk over to the Ontario County Courthouse and go into the surrogate court clerk and go on their public computers, and you can read everyone that's ever died's will. You can see their finances, you can see their inventory of assets, you can see. Now, I don't think anyone's that bored that they want to go research random people's obituaries and see what's going on in their estates. The only reason I do it is because I have to. I'm an attorney and I do this stuff. And I did want to see my uncle, my great uncle, who was the treasurer of Ontario County in the 1960s. And I wanted to see, just genealogy purposes, it has some value. But let's say, for whatever reason, you don't want someone to know something. And when you die, if it's a probated estate, the person you don't want to know something can know that. With a trust, it's a private document. If you're not in the document, you don't get a copy of the document, and you have no right to the document. So there's some secrets, basically, you want to keep, and who knows what those would be. What was the one in law school? He was a TV personality. And for 20 years, he had a side girlfriend and a family with her, and he had a house in Wyoming set up. So I don't think it was Walter Cronkite, but it was somebody. But anyway, he set up a trust so that his wife didn't know that he was leaving her all this money. And unfortunately, it all came out anyway, otherwise it wouldn't be in a textbook that I read in law school. But one example, not suggesting you all need to do that. You want to talk a little bit more about trusts?
Sure.
Split it up.
So one of the other benefits of a revocable trust is if somebody has long-term care insurance, they're not concerned about going into a nursing home, but they own multiple pieces of property. Or they own property outside of New York State.
estates.
A revocable trust is a good vehicle to transfer those assets onto your beneficiaries seamlessly. Now, in the event, so we have a lot of snowbirds up in this area. So you own property in New York and you own a condo in Florida. I have everything in New York taken care of. We've got beneficiaries on it. I put the New York house in a trust where my kids' names are on it, but I forgot about Florida. Florida probate is ridiculous. It's time consuming, it's expensive. Oh, by the way, just because I got rid of the probate in New York, I still have to do probate in New York to get to Florida.
Yep.
It's timely, it's costly. So if you own property in any of the other states, that's a good tool to transfer the ownership to avoid probate in that additional state.
That's gonna save you a lot.
It's gonna save you a lot of money and time, especially Florida. Florida, we've gone through it. I've got an estate right now. We are still trying to get, you have to publish creditors notices. You have to get write-offs from any creditors that you might have. All the beneficiaries have to sign 14,000 paper. It's ridiculous. And it's all one of these things. It's not cheap to do it. So by doing a revocable trust, that is going to avoid that process. Now, a revocable trust will not give you protection from a nursing home though. So again, that's utilized when nursing homes aren't an issue. We've got long-term care. There's other factors involved. The irrevocable trust, and we're talking the irrevocable Medicaid trust, because irrevocable trust, if you just Google it, there's 14,000 trusts that are gonna come up. Some irrevocable trusts are designed for tax purposes. The one we're talking about is, I wanna protect my assets from a nursing home. So that's an irrevocable Medicaid trust. Once an asset has been titled to this trust for 5 years, it's completely off the table. Now, like we kind of said before, if all I have is my house, maybe the deed is fine for you. But if we've got life insurance, remember I said cash value of life insurance counts against you. If I have extra money that I'm not utilizing, this is what I put in that irrevocable trust. Individual stocks, any extra money. Now, we never tell you, and if anybody ever does run away, to put 100% of your assets in an irrevocable trust. Don't do that. Why? You still have to live. Like we've kind of been saying this whole time, it's not cookie cutter. Everybody's assets are different. So when we're doing this kind of trust planning, we're asking, what do you have? How is it structured? What are your goals? So that we know what we can put in. And it's a numbers game. I'll sit down and say, okay, if we know how much to put in, put down this is my monthly income. These are my monthly bills. Is my income covering it, or am I pulling from my savings a lot? That's what's going to determine what additional assets, maybe besides a house, we put into the trust. Now again, you name a separate person as a trustee of this trust, and they manage it while you're alive. Just like the revocable trust, it avoids probate, so you pick your beneficiaries. Now a lot of people, like Dave said, I don't want to give up control. We build in a lot of protections for you in these trusts. You're still entitled to live in this house, and it cannot be sold while you're alive. You still get your star exemption by it being in this trust. You maintain a power of appointment, meaning, even though I picked my 3 kids as my beneficiaries today, 5, 10, 15 years from now, yeah, I don't want to leave it to this kid. We had a falling out, something happened, I don't feel comfortable leaving it to them anymore. Oh my gosh, all of my big assets are in this trust. By having that power of appointment that we put in there, you can change your beneficiaries at any time. Caveat, it does not affect your 5 years, because you're not changing the ownership of the assets. So at any point in the future, as long as you're still competent, you can change the beneficiaries and you don't restart your clock for that 5-year look back. The other benefit is each asset has its own clock. So sometimes we'll get people who come in and say, well, for today I'm only comfortable putting my house in. But next year let's talk about this because I'm making some moves, something's going on, I'm not sure what assets I'll have. Okay, so let's reassess then. So we put your house in June 1st. We're starting our 5-year clock. July 1st, 2026, you come in going, okay, I want to put $100,000 into this trust in my life insurance policy. By now transferring new assets to this trust, we do not restart the clock that had already started on the house. Each asset that you put in has its own individual clock. Now, people will also ask us too, well, I get it, it's the 5-year look back. What happens if we don't make the 5 years? What if I die? Death is okay. We just don't want you to go into a nursing home during that time. I have had it where people have not made that 5 years before going into a nursing home. So my first question is, when did we put these assets in? How far into this clock are we? Is it worth it to private pay 2 months at the nursing home to get past this to protect a $300,000 house? It's a timing issue, really. So sometimes it's never too late to do something. Again, if you do no planning, there's always a way we can save it. But that's the big difference between the typical trust that people do. The revocable, you're gonna avoid probate. The irrevocable, that's where you get your protection from a nursing home. And again, we always build in those protections. You don't have to put 100% of your assets in. It really just depends on how your assets are structured. We never, ever put retirement money into an irrevocable trust, because the moment you change the ownership from you to the trust, the IRS is, like I kind of mentioned before, is going to say, it's not you. I said, you could have that tax exempt status for now. Now you're transferring to somebody else, it's all taxable. Again, that's the other reason Medicaid does not count retirement money as an asset for that principal value. Now, any questions on that?
Yeah. Well, one question, if you have a good long-term health insurance policy, does that pretty much protect you from this Medicaid thing?
Sometimes, yes. It depends on the policy, to be honest with you. There's the typical policies out there. The best one on the market right now is called a New York State Partnership Plan. How those are designed is after 3 years, you're automatically eligible for Medicaid, no matter what assets you have. Typically, long-term care insurance right now is paying out around 3-ish years. But that type of policy is more expensive. You're talking $9,000 to $11,000 per year. The typical long-term care insurance that most people have is around $5,000 to $6,ish thousand per year, and that'll cover 3 years at a nursing home, but it'll also cover home care. But once that is exhausted, if you're still in that nursing home needing care, you apply for Medicaid like everybody else. So now you're subject to those $32,000 or $100,000 asset restrictions. So I'll be honest with you, it depends. Sometimes if somebody's like, hey, mom and dad are doing really good, we're utilizing a lot of their long-term care policy for home care, maybe we start taking steps to move some assets around at that point. But there's typically always something that we want to do. So a lot of times in that scenario, people will do the revocable trust to say, well, at least want to avoid probate for the real estate, still have complete control over it. The Medicaid irrevocable trust, I've had people say, nope, don't want to touch it, or yes, just in case I make the 3 years, you never know. My Uncle Johnny, rest his soul, lived to 105, he was in a nursing home for 8 years. We don't know. We have people who go in and unfortunately pass away in a couple months. There's no guarantee of how long somebody will be in a nursing home. So it depends. It really depends on the type of policy. So I always say, people bring in your policy. I can tell you by looking at the first page what type of policy you have. Yeah.
Do you do that? Do you work with the insurance company? Will you be the in-between if what we decided we needed to have it?
We can help, yes.
Ours is long-term. There's no limit on it, but it's 20 years old too, so.
Okay. Yeah, and it really depends, because unfortunately, long-term care insurance has really changed over the last 20 years. A lot of them that were older were good. It really depends. Some of them probably 10-ish years ago, a lot of companies were starting to get out of it. It's kind of a use it and lose it. So if I never go into a nursing home and I paid into these policies, there's no benefit for my beneficiaries at the end of the day. Now there's really very few companies doing it, but they use it as like an insurance rider. So you have a $300,000 policy, I exhaust $100,000. If I have 200 at the end of the day, my beneficiaries get that paid out like a life insurance policy. So it depends. I'll be honest, it really depends with what type of policy you have. So I always just say, just bring it in, we'll go over it. If you're already into a plan, it's hard to change it, but a lot of times I'm like, we've been paying on it all this years, at least keep it if you have something. Some people have one that are more geared towards just home care. They're like, why am I paying $5,000 when it's only gonna cover maybe 3 months? I'm like, maybe that's not worth it to keep anymore. So it really just depends on the type of policy, to be honest, because there's so many out there, because each company, we're like, well, I want to do it a little different than this one. So it depends. So I always say just bring it in if you have it, and we'll take a look at it.
If you have a house that, if you go into a nursing home and you didn't do all of these wonderful things you're talking about, and the nursing home is using your home, your house, collateral or whatever to pay, that house cannot be sold, right?
No, it can.
It can be?
It depends. No, it can still be sold, because I did this last year where husband, there wouldn't be a lien yet. Because if you do it pretty quick, so mom goes into the nursing home, she still owned her house, we're applying for Medicaid. Sometimes it depends, like, did they have a mortgage? Did they have a reverse mortgage on it, or did they own it free and clear? So sometimes we'll say, well, let's get this on the market now, because, hey, we're gonna get $300,000 for this house. So again, we're under a private pay scenario still currently. So we'll say, let's sell it, mom pockets the money of $300,000, let's prepay her funeral if she doesn't have it. Then because she's over-resourced, we're gonna do that gift and loan strategy for the rest of it to protect it. So it's really situational, like how quick do you act to try to take that step? If it's mom's been in the nursing home for a year, she's got a house that's mortgaged to the hilt. If you sell it, the mortgage company's gonna give up, there might not be something you can do. Or the equity you had in it, you've already spent at the nursing home. So the quicker you respond to saying, mom's going into a nursing home, she's got a house, we've gotta do something, the quicker you act, the more we can save and potentially do something.
Right. It's also, I hear a common misconception, or maybe it's the way people phrase it as well, that the government's gonna come take my house. It's not exactly how that happens. If you do nothing, you're gonna rack up a bill, right? Whatever the number is gonna be when you pass away. I did one recently, it was around 120,000. That was owed back to the government, and they're gonna file a lien against your estate. And then when you go to sell the house, you're gonna have to pay off that amount of money. If there's more money than what's owed, then the estate will keep that money. If there's, I don't know, in this particular case, that Medicaid lien wiped out the entire estate. The only thing that we really had was the house. It was not worth what the lien was, so we had to pay, the entire estate went to the lien, and there was nothing left for the family at all. So, and people say, oh yeah, it's not like you apply for Medicaid and then the next day they come seize your house and lock the doors. People have that misconception, I think, they think that, or we can't sell the house because of the Medicaid. You can, if you were to sell the house while on Medicaid, they're gonna sue the estate eventually for the money if you don't leave that money in a place within the estate that can pay the lien. Any other questions on that? Because we only have a few minutes left. I just want to briefly touch on the POA and UCP.
I just, on the TOD, on the transfer upon death, if you put your house in that, and I realize it doesn't do anything for nursing homes, you put your bank accounts in that transfer on death.
Mm-hmm.
You have any stocks and bonds all situated with your children. What's left? I mean, if everything's transferred on death, and say you do have long-term care insurance, so you're not worried about the 5-year, what's left besides cars? What am I missing?
There might not be anything that goes through probate. Again, you still always have your basic estate planning document, so you still have your will just in case. Again, worst case scenario, the bank doesn't exist 2 years from now. You also have the power of attorney and a healthcare proxy. So the power of attorney is the person you appoint while you're alive to handle your finances for you in the event you become incapacitated. And it might not be a mental incapacity, it could be a physical incapacity. I physically can't go to the bank anymore. I physically can't sign. So you want that document, because without that, you're doing guardianship with the court. Again, it's expensive, it's time consuming, somebody might be appointed that you would not have wanted. So you appoint the power of attorney while you're alive. Now, people get nervous with the power of attorney by saying, well, I'm giving them all this control, they can just go in and take out my bank accounts. Could they? Worst case scenario? Yes. But the law has protection in place because whoever you pick as your power of attorney is a fiduciary. They have a higher standard to how they have to act. So if I name my brother as my power of attorney and he goes in and takes out all my accounts, I can sue him. He's gonna have to pay it back, and he could have jail time as a repercussion for not acting as how I would have. Just like what we've always talked about, you want backups. Make sure you have backups. You can name alternate power of attorneys. Oh, the people I picked 10 years from now, like I don't want them anymore. I'm still competent, I can change it. I can revoke my old one and create new people. You also want your healthcare proxy, and that's the person who makes healthcare decisions for you in the event you can't make them for yourself. Like we said before, New York State does have a rule on who gets picked if you don't have it, but again, that might not be the person you want. So this is where you can pick who's my alternate in the event my spouse, something happens. Again, in my scenario, my brother's a better choice than me. I have no idea what they're talking about. Again, not to say he's not gonna talk to me, but he's gonna be better apt to understanding what is happening.
Is there a place on the internet where those forms are? Does New York State have a place where you can get those forms?
New York State does, because the power of attorney is a statutory form. However, what is key is where you initial. And there's also on the form modification section that New York State leaves blank, where we as estate planning attorneys have to fill in to add in extra authority, because we see what the banks want to see. They want to see the specific authority that they can obtain records, they can obtain statements.
Yeah, the statutory power of attorney has changed significantly from 2009, I believe. Used to be a legal size document, you sign your name at the bottom, pretty much, you initial one box, and away you go. Now the document is much longer, much more complicated. As Meghan was saying, not only are you gonna appoint these general powers over the years, the legislature has amended it to say, but within those, for example, you're gonna give your power of attorney the power to handle all tax matters, right? That's pretty all-encompassing. All matters having to do with taxes. But now the banks want to see that your power of attorney specifically says, the IRS wants to see in there that you've given your agent the authority to sign certain IRS forms. You would think that would be covered by the word all, right? All tax matters. But they don't want to hear that. They want to see these specific things. And the document now goes on. I get this question a lot, well, can't I just do it myself? Maybe. I could probably buy all the tools to do a root canal myself, but I'm not going to do that because, I could try to figure out how to change my own oil, but I'm not going to do that because there's so many nuances. Just think of how many questions came up today in an hour and 55 minutes. If you're just printing out the form and filling it out, I'm not saying people aren't perfectly capable of doing that, but there's no one there to answer any questions, no one there to explain what these things are. And the healthcare proxy, we do a living will. It's the first page of our healthcare proxy. It's an advanced directive. It says, in the event that I cannot eat or drink enough because of my permanent vegetative state, 2 doctors have declared me incapacitated, and no hope of recovery, then we're going to direct, what do I want to see happen in that? Do I want to have artificial nutrition and hydration or not? And then one of the things I like about that document is now you've made the decision for your family, and you're not leaving the burden of that, in that one circumstance, on anyone else. And if the healthcare agent says, well, here's the document, mom didn't want to be on the freedom tube in this situation, they're off the hook. The rest of the family's not going to let you kill mom, basically. You made that decision. No, mom made that decision 6 years ago when she filled out this paperwork. It's critical. And it's interesting, you make a good point. There are plenty of circumstances where people die and there really isn't anything they need to do. The bank account was joint with the kids and the house was already transferred. Maybe there's a car, maybe an exception qualifies, or maybe we have to open what's called a small estate, voluntary administration, where instead of getting appointed as general executor, you're just appointed to transfer that one thing, and that's it. Very simple. But that doesn't mean your estate plan ends there, because a lot of what we've talked about today is things that are for when you're gone. But while you're alive, there's all these other documents that you need. We don't want to have a fight over who's going to be mom's healthcare decision maker. We don't want to have a fight over dad. I get this call many times a year. We need a power of attorney for dad. Okay, well, where's dad? Well, he's in the nursing home. Okay, why is he in the nursing home? Because he has dementia. Okay, well, he can't sign the power of attorney. They're like, yeah, but we can't pay the bills, the mortgage company won't talk to us, the car payments are racking up, and all of his car payments go to his email, and we don't have a password for it, and no one will talk to us because we're not power of attorney. So these documents are very important. And the last thing I want to kind of talk about is what I just touched on. We're living in a very interesting age. When I first started practicing law, 17 years ago, whatever it was, when someone died, the family would come in with buckets and bins of paperwork, right? Mom had this stuff all piled up, life insurance policies from the 1940s that we have no idea if they're still in effect or not. Now people come in with maybe a vanilla folder, bunch of passwords, everything's digital, everyone's stuff is online. I think I get 2 actual paper bills at my house, and the rest of it's all PDF to my email, it's set up on auto pay. If I die, how's my executor gonna access that information? So I've run into a lot of circumstances where we know we had, but we can't find the information on it because it's all trapped behind a password, and it's kind of difficult to, and there is no great answer to that. Do you leave your password? I used to tell clients, well, you could make a list of all your accounts and your passwords and whatnot, all your important information, put it in a manila envelope and leave it. But now, in the last couple of years, everything's, multiple factor authentication, and you get a text, but we can't get in dad's phone because he has a passcode on the text, and and they make you change your password every 6 months. So it's an ever-evolving logistics of estates. So it's something to think about. And one other thing I like to tell my clients is, you're the only person that knows what you own. We kind of forget the small stuff sometimes when we're talking about these heady concepts. And what I mean by that is, I have a dresser in my house. It's in my son's room. It's complete trash. You wouldn't buy it for $10 at a garage sale. But my great-grandfather made it. It means something. It has that sentimental value. Make a list for your family of those things that are maybe family heirlooms that when you're gone, jewelry is a perfect example. I'm a man. I have no idea the value of jewelry, nor could I pick a real diamond out from costume jewelry, right? So if you die and you have something that's valuable, because you know that it's an actually valuable thing, make note of it. Otherwise, it might get thrown out, it might get donated to the Salvation Army. That picture on the wall that we don't really like, that Grandma always had, but it turns out it's a Monet, I don't know. We've seen that happen, where people just, this is kind of junk. I collect books, I collect old books. I come to the Wood Library book sale. I try to find diamonds in the rough, but there's this group of guys that always seem to beat me here early in the morning. But I've told my kids, I know they just look like old dusty books, but they're not. Do not just donate those to Salvation Army. There's a lot of value in some of those books. So make a list of kind of all these little notes and things of everything from what song do you want played at your funeral to what things of yours have value, either dollar value or sentimental value that you just want people to know. Because once you're gone, the entire knowledge of your life is gone. We can't ask you anymore any questions unless you leave a list. So it's an important note. Any other questions, thoughts?
I have one.
Yeah.
If you don't have a healthcare proxy, but you do have someone who has a power of attorney, can they make decisions on do not resuscitate?
No. Your power of attorney only has authority over, we'll say, financial or life management. Your health decisions of any type are completely separate from your power of attorney. Your power of attorney can talk to the hospital about your billing, about that type of stuff, but the medical decisions, you've either already made them or someone has to get appointed to make those. Same way your healthcare proxy or your guardian, your health guardian, doesn't have any authority over money.
Yes,
Are you gonna have cards?
yes, we've got cards, we've got some pamphlets, if anyone has. Thank you all so much for coming. If you have any other questions, please let us know. Our information's on the back of this, and we hope everyone got at least a little bit of information out of what the documents are, and thank you, Wood Library, for helping us.
Thank you very much.
Their office is just down the street, on Main Street. So close by, you can come to the library, then go visit Dave and Meghan and straighten out your life. Anyway, thank you all for coming. We have started offering these workshops a couple times a year. They're always well attended. There's always a lot of questions. Clearly, it's a topic that people are interested in. So let your friends know. I'll be setting up another series of workshops in October. So look for that on the library news. Thanks for coming. Thank you.
No, thank you so much for coming.
So we did record this, so yes. Yeah, he was the biggest. All right, well, thank you. So this is the, okay, this is the main newsletter.
Come out there.
I'm glad that you're interested. Regarding this topic. So our newsletter, if we're doing.
Finish it?
Oh, so whenever, should we do a monthly newsletter? It has programs that we offer in that month. So that's a good way to sort of stay on top of what we're offering. Just, you know, see all the stuff she has. This is May.
I'm happy that was one of my clients who went to the front this week.
We are, and so the calendar is on the library website. Right here, and the calendar, you can see everything that's going on by day, we can register.
Yeah, let me get in one of our, okay, so one of our panelists to her car. We're gonna try to do this again soon. We've got one coming up with other assisted living.
I would say, parish building, just make sure you always get them on this.
But at least here's some basic stuff. So you can always just schedule a phone call with us, we go over everything we do today, specific to you, because we do in our council.
That's what,
Right down the road, actually, like one street down. I'm pointing this way, we're off, right on Main Street. Right on Main Street. I'm like, I can turn around and go like this.
Where are you going to go and make stuff legal? That's the one thing.